dispute was among respondent number 5 and 6, my lords. Ultimately, the learned single judge has come against me, my lords. Now, what has happened? Respondent number 5 has preferred a writ appeal before this court, and this honourable court was pleased to grant an interim relief in that appeal, lords.
आप अपना मेमो अपील पढ़िए. You have admitted everything.
That it was a mistake, my lords. But
just a minute, sir.
Yes.
You have admitted everything. That you are merely a clerk, in charge section officer. You prepared the order. Everything was done by you.
My lord.
You say it is a bona fide mistake. You could not understand the order passed by the High Court. अगर आपको 2 लाइन का सिंपल अंग्रेजी का भी ऑर्डर समझ में नहीं आता है, आप अपीलेट अथॉरिटी हैं.
My lord, I will point out intelligence in that, my lords.
Just of all, let us start from the order which was issued by this court.
Yes, my lords.
What was the original order?
My lord, the original.
Just to decide the appeal against the order of.
That was there, my lords.
Right.
But my lords, one thing is there. My lord, the executive engineer specifically says that he reinstated the respondent number 5 on his own. My lord,
तो है उसके खिलाफ भी तो FIR.
Nothing, my lords, nothing.
भाई साहब.
Nothing is there, my lord, against him.
300.
FIR is against me.
Sir, please. अब आप चाहें तो आपके पूरे बार के सामने आपकी पूरी अपील पढ़ देता हूँ. फिर आप कुछ भी वैसे नहीं कर पाएंगे.
My lord, FIR.
In the entire memo of appeal, you have admitted everything. And before the writ court, you had admitted everything. Now you want that you should be allowed to go scot-free? Why?
My lord, for that departmental proceeding is going.
Yes,
my lords.
yes.
But my lord, now possessive of this order, my lords, this Honourable High Court order, the criminal proceeding is only initiated against me.
Fine, yes.
And my lords, what is the today's status, my lords? Mr. Ghanshyam Sen, against whom the dispute was there, this Honourable Court has issued notice and granted him interim relief, my lord. My lord, ultimately, I am not the beneficiary of the. I may be default on a part that I committed an error. Committed an error, my lord.
What a honest argument, sir. I am not the beneficiary. I am maybe a defaulter. Do you think this is the reality?
Yes, my lord.
Oh, sir.
My lord, that is the fact, my lords.
तो यही तो पुलिस को पता करना है.
My lord,
आपको कितना बेनिफिट हुआ?
My lord, nothing.
You are nobody, but you prepared the order of revocation.
What is the effect of that order, my lords?
Whatever it may be.
My lord, it's not.
Mr. Counsel, whatever it may be. Once you had no authority, why you prepared it? Why do you, I think it was signed by you also.
No, my lords.
मैं देख लेता हूँ आपके एडमिशंस क्या हैं. क्या एडमिशंस हैं आपने? इसीलिए मैं रिप्रेजेंटेशन के ऑर्डर्स नहीं करता हूँ. मुझे मालूम है कि सब वहाँ पे नीचे जाके भ्रष्टाचार होना है. एक बाबू उठा के अपीलेट अथॉरिटी के पावर एक्सरसाइज कर देगा और अपीलेट अथॉरिटी को डायरेक्शन है और बाबू जो है रिवोकेशन का ऑर्डर पास कर देगा.
My lord, वो
क्या my lord यार? ये है हमारे ऑर्डर्स के इस तरीके का मिसयूज. आप कहते हैं कि आई एम नॉट द बेनिफिशियरी. What do you mean by beneficiary?
My lord, this order was not in effect, my lords. And my lord, अगर उस order का effect हो, then I will be not.
Whatever it is.
I don't have any case, my lord. But my lord, kindly appreciate executive engineer ने उनको अपने power का exercise करते हुए.
ओ मेरे भाई, आपने अपनी seal, अपने signature और अपने order अपने.
My lord, अगर हम अपना signature use कर रहे हैं, तो how it can be said? My lord, the order.
बाबू हो. Don't try to impress upon us कि as if you are working as superintending engineer or the appellate authority. Mr. Counsel, once you don't have any authority, then neither you can sign nor you can put your seal. At the most, you can take dictation and then hand it over to the person who was competent. क्या बहस कर रहे हो यार? एक अनऑथराइज्ड आदमी सस्पेंशन रिवोक कर देता है हाई कोर्ट के उस ऑर्डर को मिसयूज करते हुए कि जिसमें हाई कोर्ट ने अपीलेट अथॉरिटी को अपील डिसाइड करने का डायरेक्शन दिया.
With due respect, my lords, हमारे ऑर्डर से सस्पेंशन रिवोक नहीं हुआ था, my lords. That is the case, my lords.
Right, fine. No, sir.
My lord, then connect my matter with the.
No, sir, sorry.
My lord, the writ appeal is.
Sorry, the facts are different, allegations are different.
My lord, the allegations are different.
WA 1214 of
my lord, मैं एक चीज देख ले lords.
पता है ना?
My lord, executive engineer gives a specific affidavit that on his own he has reinstated Ghanshyam Sen because he was retired.
आएगा भाई साहब, पुलिस जब पूरा इन्वेस्टिगेशन करेगी ना तो पक्का स्वप्निल जी से पूछेगी और कौन बन रहा है.
My lord, I'm sorry, my lord. My lord,
स्वप्निल जी सबको ले ले. चिंता नहीं करो.
Protected today, my lord. No, nothing.
चिंता मत करो.
So cause notice हमारे खिलाफ है, my lord.
कोई बात नहीं. FIR भी आपके
suspended today, my lord. Everything is going on against.
FIR भी आपके खिलाफ है.
My lord, FIR भी हमारे खिलाफ already हो चुकी है.
बहुत अच्छा हुआ सर.
But my lord, हमारे उस ऑर्डर का अगर कोई इफेक्ट हो, and my lord, that I have admitted a mistake. For that, I against be a.
बहुत अच्छी बात है सर. बहुत अच्छी बात है.
क्या एक चीज के लिए can fine for an offence can be several proceedings?
Mister, don't argue against the settled law.
As per my lords.
What is the law? Whether the criminal proceedings and disciplinary proceedings can go simultaneously or not.
My lord, definitely.
Don't put a question to us.
Definitely can go, but 300.
1-1-4/2024.
There's no double jeopardy, my lords.
Mr. Counsel,
is not completed yet, my lord.
Mr. Counsel,
this is not completed.
Mr. Counsel, double jeopardy के provisions आज Constitution में कहाँ पे हैं और CRPC में कहाँ पे हैं? दोनों जगह पे provisions हैं, बताइए.
My lord है, but
बताइए.
But my lord.
Oh, Mr. बड़ी तेज आवाज में आप बोल रहे हैं ना? अब हमें नहीं मालूम, बताइए.
Definitely, lordship.
नहीं मालूम हमको. हम भी तेज आवाज से बोल रहे हैं.
Trying to say, my lord.
Mr. Counsel, please. कौन से आर्टिकल में है कॉन्स्टिट्यूशन में डबल jeopardy?
My lord.
सर आर्टिकल बताओ. मिलॉर्ड नहीं है आर्टिकल.
My lord, article 12 subclause 2 deals with this double jeopardy.
Article 12.
Yes, my lords.
Article 12.
Article 12 deals with the double jeopardy. I'm sorry, my lord. Article 20 subclause 2 deals with the double jeopardy.
Subclause 2. What does it say?
Lord, It says that for a single offence there will be multiple proceedings, my lords.
है,
What I'm
है,
trying to say, what I'm trying to say,
है, क्या कह रहे हो?
मतलब मैं
लाला भैया कॉन्स्टिट्यूशन
my lord, what I'm trying to say,
कॉन्स्टिट्यूशन तो सीधा सीधा क्यों नहीं बोल रहे हो? मालूम है कि उसके बाद अगले क्वेश्चन आएंगे फिर आपको परेशानी आ जाएगी। जी सर।
my lord, हम कुछ और कहना चाह रहे हैं. What I'm trying to say, कि मतलब डिपार्टमेंटल प्रोसीडिंग अभी हमारे खिलाफ चल रही है. That will be concluded, that will take its course.
कोई बात नहीं सर।
मतलब FIR on a similar time, my lords. On this order repression, my lords.
कोई बात नहीं सर।
और मतलब जो मेन आदमी उनके खिलाफ स्टे है this court.
कोई बात नहीं।
That is my only point, my lord. I'm nothing pointing else apart from this.
WA 121/2024 इंट्रा कोर्ट अपील अंडर सेक्शन 2 ब्रैकेट में 1 ऑफ मध्य प्रदेश उच्च न्यायालय ब्रैकेट में खंडपीठ को अपील ब्रैकेट क्लोज अधिनियम 2005 has been filed against the order dated 15/4/2024 passed in WP number 2396/2024. The facts of the present case lies in a narrow compass. One Ghanshyam Sen SEN was placed under suspension. He filed a writ petition which was disposed of with a direction to the appellate authority to decide the appeal. However, the undisputed facts are that the petitioner, who was working as clerk and in charge section officer, prepared an order of revocation or suspension on his own and under his seal and signatures. It is submitted by counsel for the petitioner that the petitioner is being departmentally proceeded for his act and the simultaneous prosecution under criminal law would amount to double jeopardy. It is further submitted that the writ appeal filed by a co-respondent, namely क्या है, किसकी अपील है?
Ghanshyam, I have the writ appeal order, my lords.
आप बताएं?
Writ appeal number 10.
Parties ने बताएं?
Ghanshyam Sen versus the managers.
That Ghanshyam Prasad Sen has also filed WA number. क्या है सर WA number?
WA number is 10/25 of 24.
10/25 of 2024 and notices have been issued. Consider the submissions made by counsel for the appellant. In the present appeal, the undisputed facts are that by misinterpreting the order passed by this court on 23/9/2023 in WP number 23904 of 2023, the petitioner issued an order of revocation or suspension on his own and under his seal and signatures. This fact is also admitted by the petition appellant in the memo appeal also. The only contention of counsel for petitioner is that the criminal prosecution of the petitioner would amount to double jeopardy and accordingly relied upon Article 20 bracket 2 of Constitution of India and under Section 300 of CRPC. Heard the learned counsel for the petitioner. So far as the notices issued in the writ appeal filed by the other agreed person is concerned, the same will not have any effect on this case because in the present case, the petitioner who was holding the substantive post of clerk and was had issued the order of revocation or suspension on his own and under his own signatures and seals. The appeal against the order of suspension was already pending and this court had directed for disposal of the said appeal. The petitioner was not in any manner authorized to issue the order of revocation or suspension. Furthermore, the defense taken by the respondents in the before the writ court that since Ghanshyam Prasad Sen was due for retirement, therefore the order of revocation or suspension was passed. But the Honourable single judge found that there were 2 working days prior to retirement of Ghanshyam Prasad Sen and therefore there was no need to issue an order of revocation or suspension. Even otherwise, once the appellant had no authority whatsoever to issue an order of revocation or suspension, then whatever was done by him was illegal. Article 20, sub-article 2 of Constitution of India and Section 300 of CRPC would not apply in the present case. It is not the case of the petitioner that he has already been prosecuted and punished for the similar offence. It is well established, his only contention is that since he is being proceeded against in a departmental inquiry, therefore, he should not be criminally prosecuted. The aforesaid submission is not covered by the doctrine of double jeopardy. The Supreme Court in the case of so-and-so has held as under, thus it is clear that on similar allegations, the criminal proceedings as well as the departmental proceedings can go on simultaneously. As no error apparent on face, as no error could be pointed out by counsel for the petition appellant, accordingly the appeal fails and is hereby dismissed.
I'm obliged, my lords. My lords, out of the record, I will say one thing, my lords.
sir.
There are some cases, my lords, in which the departmental proceeding and FIR not continuing simultaneously. There are orders
मैं
of
आपको
Supreme
बता
Court as well.
मैं आपको बता देता हूँ, आउट ऑफ द रिकॉर्ड नहीं बताऊंगा, ऑन द रिकॉर्ड बताऊंगा।
नहीं, my lords, मैंने एक दो केस सुप्रीम कोर्ट में
सुनिए,
किए, so I know very well about it.
आपने एक दो पढ़े हैं, हमने हजारों पढ़े।
No, no, I'm doing a case, that's why I'm saying that.
आप कर रहे होंगे, हम डिसाइड कर रहे हैं,
Yes,
चिंता ना करिए।
that's
बहस करना और डिसाइड करना में अंतर होता है।
There are two types of law going on in this.
सुप्रीम कोर्ट का ये कहना है, indefinite stay on the criminal proceedings or on the criminal proceedings is not warranted, right?
Correct.
बीच में एक फेज आ गया था जब क्रिमिनल पॉसिबिलिटी ऑफ डिस्क्लोजर ऑफ डिफेंस के ऊपर क्रिमिनल प्रोसीडिंग स्टे हो रही थी, राइट? फिर वो हटा, फिर ये आया कि नहीं अब स्टे नहीं हो सकता है, ये भी है। Ultimately, law is that the criminal proceedings cannot be stayed for indefinite period. Fine, thank you, sir.